coming up.
So when I was backing out, did feel something like a tap or something, and I thought, oh, maybe I possibly hit it. I did get out and check. I didn't see any damage when I looked, and so I went on my way. I was on my way to an important appointment, and I couldn't be late.
Your dog, your rules, your responsibility. That's not a legal argument. That's the exact sentence that walked into a courtroom, sat down across from a ruined mattress and a wrecked car, and asked a judge to sort out what common sense could not. 2 cases. 2 defendants who were absolutely certain they were not at fault, and 1 courtroom where the evidence said otherwise. Before we go deeper into what the documents actually show, make sure you're subscribed to Real Court Case Verdict, because we don't just cover the story, we follow the evidence.
Ronnie Tran claims he was forced to buy a new mattress after a co-worker's dog soiled his bed while he was pet sitting.
All rise.
Hillary Ryan says she was willing to pay for professional cleaning, but not a new mattress.
Court is now in session. The Honorable Judge Lauren Lake presiding.
You may be seated. 1. Ronnie Tran versus Hillary Ryan. The claim? $3,000 in property damage caused by a dog named Shadow, a 5-year-old sheepoo described by his own owner on the record as a diva.
Ryan, Mr. Tran, you are suing Ms. Ryan for $3,000 in property damage. You say the defendant's dog ruined an expensive mattress. Ms. Ryan, you say the plaintiff was warned to keep an eye on the dog. Is that correct?
Yes, Your Honor.
All right, I'll start with you, plaintiff. What happened to your mattress?
Hillary and I are co-workers, and typically she talks to me about her dog Shadow. She talks to me about him as if he is the love of her life and always makes her day brighter.
What kind of dog is Shadow, Ms. Ryan?
A sheepoo.
A sheepoo, okay.
Mm-hmm. I'd like to make a note that I also say that the dog is a diva at work.
Okay.
A diva dog.
Picture this.
Noted.
A mattress, a studio apartment, a day party that started at 1 in the afternoon and ended at 8 at night. And somewhere in that 7-hour window, a diva dog made a decision that nobody saw coming, and nobody will ever forget. That is the image that defines this entire case. Not the poop itself, the gap. The 7 hours of silence between "he'll be fine" and a girlfriend screaming from a bed she would never voluntarily sleep in again. Hillary Ryan left written instructions. Walk the dog twice a day, keep clean puppy pads down, keep Shadow in a secure spot if you leave. She submitted those instructions as Exhibit A.
All right, then what happened?
So later that week, she brought over Shadow and explained everything that he needed, which wasn't too much. She just said that to try to walk him 2 times a day if possible. She gave me plenty of puppy pads to put down if I couldn't walk him or if I was out of the house so that he could pee on them. She made it clear to make sure that they were always clean, not soiled.
You left him a list?
Yes.
All right.
In writing.
You submitted your evidence to the court and you say this is Exhibit A. Kind of last minute, would you be able to watch Shadow? I'd actually love to. Make sure there's clean puppy pads down.
Yes, she did. She explained everything, and she told me that if I ever needed to leave the place, not only to keep a clean puppy pad, but to keep Shadow in a secure spot. I don't have as big of an apartment as Hillary does. I kind of live in a studio, so I don't really have any other doors besides my bathroom door. So everything was fine. I knew all the rules, I understood it, and I felt like this would be easy. Taking care of Shadow would be nothing, and I love dogs, so what's another dog?
How do we get to 3?
They were real. They were specific, and they did not say one thing. Do not leave this animal alone for 7 consecutive hours while you attend a day party. Your dog, your rules, your responsibility. Ronnie Tran is not a dog owner. He said that himself. He was doing a coworker a favor.
Yes, I've heard a lot about Shadow. She talks to me about him all the time, and one day at work, she asked me if I would be down to dog sit for roughly 2 weeks.
And where were you going that you needed a sitter for that long?
Overseas. I was going to Europe with my family, and I couldn't take Shadow with me, so I know that Ronnie's expressed how he's trying to experiment to see if he could be a dog owner, and so we felt he was doing me a favor, which he was, because he denied my payment, but I definitely was willing to pay him for the time that he was.
How old is Shadow?
Shadow is about 5.
Okay, so an older dog.
Yes.
All right, so you agreed to keep Shadow.
I thought it'd be a
Running
fun.
what he called a trial run to see if he could handle having a dog. He walked Shadow in the morning. He left a clean puppy pad. He went to the party.
One day, on like a Saturday, at 1 p.m., I had a day party that I went to with my girlfriend. So I took Shadow out to walk in the morning. He went to the bathroom. Before the day party, I left out a clean puppy pad because that's what I was instructed to do. And I left to go to the party, and I left him in my apartment, in my little studio, because I felt that it was a secure enough location for Shadow. And all was well, I thought, until I came back from the party at around 8 p.m. But basically, I did smell something in the studio, but the puppy pad was clean, so I figured it was just the trash. And then a few moments later, my girlfriend ended up screaming, and I didn't know why. So I turned around, and it turns out that when she pulled off the cover to go into bed and got into bed, she ended up putting her foot in a pile of Shadow's business.
By his own testimony, he came home at 8, smelled something, assumed it was the trash, and did not investigate until his girlfriend pulled back the comforter and put her foot directly into the evidence. Now here is where this case gets forensic. The dog did not poop on the mattress. The dog pooped on the duvet cover.
Of the poop, I hope not.
Maybe just for our eyes only, Your Honor. But I did.
But that's not under your duvet cover, that's on top.
The duvet cover was pulled over.
Oh, you pulled it off.
Correct.
Okay, so that was the comforter that was under.
Correct, the sheets.
All right. Well, I guess,
Yes.
unfortunately, it is evidence that is relevant to this case that I have to look at this poop.
Yes, Your Honor. So now I'm dealing with an upset girlfriend with poop on her heel. And,
Oh, she hasn't cleaned it yet?
well, I helped her clean it. But basically, she told me that she would not be comfortable sleeping in a bed anymore with dog that had crapped in it. So I stripped the bed with the sheets, I threw it in the wash and dried it. But she told me that as long as
Between that comforter and the actual mattress surface, sheets, more fabric, and, as the court noted with some concern, no mattress pad. Not one. Tran had no mattress protector on a mattress he is now asking $3,000 to replace. The mattress was not presented as visibly destroyed. No staining evidence on the mattress itself made it to the court record. What made it to court was a photo, reviewed for evidentiary purposes, and a girlfriend who had decided her comfort threshold had been crossed permanently. Judge Lake was precise. A professional cleaning company, new sheets, new duvet, a mattress pad, which Hillary Ryan had already offered to purchase. The total? Somewhere between $750 and $1,000. That is what the damage actually cost, not what the girlfriend's emotional response cost, not what replacing the memory of a soiled mattress costs, what the damage cost. Your dog, your rules, your responsibility.
So, Ms. Ryan, how do you respond to this?
I offered to pay for new sheets, but a new mattress, which he didn't even feel like he needed until his entitled girlfriend said, "I'm not sleeping in a mattress that has ever had poop in it." So I don't believe I need to pay for a new mattress because he ignored the dog when I said, aside from the secure area, aside from the poopy pads, I told him to give the dog attention. And if you don't give the dog attention, the dog will be a little diva.
Did you get any estimates of how much it would cost to clean it?
I did not.
Judgment for the plaintiff. $1,000. Not $3,000.
You had a
One.
mattress pad.
He did not. And I offered to buy him one after this. Like, after this happened, I told him, along with the new sheets and the professional cleaning of the mattress, I would buy him a mattress pad.
And then what I'm hearing her offer you seems reasonable under the circumstance. A professional cleaning, new sheets, new duvet, and a mattress cover.
Your Honor, I listened to all the rules that she instructed me. I kept him in a secure spot. I gave him a clean pad.
But what would a reasonable person think with these rules? A reasonable person.
I'm simply replacing what I already had.
Right. You're wanting your girlfriend to be comfortable being in your bed, and that's not this court's problem. This court's issue is what damage did the dog cause, and how can you be made whole from those damages. I do think a professional cleaning company, new duvet cover, new sheets. What size was the bed?
It was a queen.
A queen size bed could be done within $750 to $1,000 could cover that. And that's about all you're due and owed right this point. Professional cleaning would probably cost anywhere from $250 to $500. And then a comforter, sheets, and those things. It's more than reasonable what she's offering. Judgment for the plaintiff for $1,000. Court is adjourned.
All right.
Case 2. Darius Coleman versus Vanessa Reed.
Darius Coleman claims his landlord let another car park in his reserved space, so he parked on the lawn and the defendant backed into him. Vanessa Reed says she doesn't know who caused the damage and the repair cost is excessive.
You say the defendant caused damage to your vehicle, is that correct?
Yes, Your Honor.
All right, Mr. Coleman, I'll start with you. What happened to your vehicle?
I was working like a double shift, and then as soon as I came home, there was a car parked right behind Miss Reed. I decided to park my car right there on the grass.
You live in the same complex as Ms. Reed?
That's right.
Okay.
He was mistaken with that and actually is a house that I own.
Okay.
And so I'm renting it out to Darius, and I rent out to him as well as other short-term.
A reserved parking spot, a street cleaning notice, a landlord decision that displaced a tenant, and a car that got hit, possibly, by someone who felt something like a tap and kept
What
driving.
happened the day that Mr. Coleman is talking about when he got in at 5:40?
So unfortunately, there was street cleaning, and you know how that happens in our neighborhoods. If you're on the street, you will get towed. And so in that case, what I actually did was I made a quick judgment, or the best judgment I could, and had the short-term tenants park in the driveway so they would be away from the street cleaning.
So you told them to park?
Correct.
So where did you expect Mr. Coleman to park?
I figured that he would park on the street, and then he could move his car once the street cleaning took place.
Did you send him a text or anything to this effect?
I did send him a text. I tried to call him, but I wasn't able to.
Do you have
reach
evidence
him.
of that text?
I don't, unfortunately, have evidence of that text.
All right, I'm looking at the residential lease here. You submitted your evidence to the court. It says clearly that no time tenant or guests of the tenants may park on the grass. Mr. Coleman, you said you pulled on the grass.
That is correct.
Why did you pull on the grass if the lease says that you should not?
Yeah, because there was nowhere else to park. So
it also says in the lease that the tenant shall have a permanent parking spot in the driveway at no extra charge. Tenant spot shall not be occupied by anyone other than the tenant. What happened?
Because she had an important appointment. Read that back. She felt something like a tap.
And why do you instantly blame her?
Because her car was pretty much like the closest, and also she told me that she possibly hit my car.
Did you hit it or didn't you? Because I mean, possibly.
Yeah, so when I was backing out, I tried my best to not hit his car. I did feel something, like a tap or something, and I thought, oh, maybe I possibly hit it. And so I went on my way. I was on my way to an important appointment, and I couldn't be late.
She felt something like a tap. She looked. She saw no damage. She left. She had an important appointment. Now here is the ticking clock question this case actually raises. If a landlord can legally redirect tenant parking, failed to reach the tenant by phone, claim to have sent a text with no record of that text, and then back a car into the displaced tenant's vehicle while departing for an appointment, who exactly was protecting this tenant's property? Because the lease was clear, in writing. Tenant shall have a permanent parking spot. Tenant spot shall not be occupied by anyone other than the tenant. Vanessa Reed, the landlord, put short-term guests in that spot to avoid a street cleaning ticket. Then she backed into the tenant's car the next morning. Your dog, your rules, your responsibility.
I knew was a recipe for disaster. But you're not a dog owner. So now this court has to look at a person who is a dog sitter, but not a dog owner. You probably look at all of these people who go out and go to work all day, and they leave their dogs in the house, and when they come back, they let their dog out. Well, you didn't even know to let them out when you came back. But that's this court's assessment here. You're a person that doesn't know anything about dogs. You're just doing a friend a favor. On the other hand, Ms. Ryan, you did leave explicit instructions about letting him out twice a day, but you didn't say in those instructions, make sure you don't leave Shadow alone for this amount of hours. If you're going to be gone for an extended amount of time, maybe we need to think about a kennel, not just for the safety of your belongings, but even Shadow's safety. A lot of dog trainers recommend kennels for dogs, not just to protect people's furniture, it's to protect the dog.
Different case, same principle. When you make a decision that puts someone else at risk, the outcome of that decision belongs to you. Reed challenged the repair estimate, $1,700 from a body shop Coleman had visited. She said she knew someone who told her it should cost less. That person did not appear in court. Their estimate did not appear in court. Their assessment of the vehicle did not appear in court.
Can I say something?
Yes.
The thing is that I don't believe that it was actually the amount that it should have been charged. So we could have worked something out. I felt like we had good communication styles, but he didn't want to do that.
What amount do you think it should be? I've got an estimate from the body shop.
Went to
now,
that
what
body
do you
shop.
think it should be?
He went to that body shop, but where the damage was located at, I spoke to somebody else, and they told me that it shouldn't be that much.
Okay, did you bring what they said to court? Did you bring their estimate? Have they seen the car? Did they come out to your house to look at it?
They came out to my house, but I do not have the estimate from them.
Judge Lake's response was direct. When you make an assertion, you back it up with evidence. You don't reference a person who came to your house if you didn't bring what they said. Judgment for the plaintiff, $1,700. Full amount requested.
I have the estimate from them.
Then I can't rule on that. See, this is the problem. When you come to court, you have to be prepared. When you make an assertion, you need to back it up with evidence.
Judge Lake's verdict when We the People returns. You're watching Emmy-nominated We the People with Judge Lauren Lake.
Judgment for the plaintiff for $1,700. You must, in the future, notify tenants when they need to have alternate parking arrangements made so that they can do that. That's what a reasonable landlord in this situation would do, and they would not try to back up out of that space without anyone trying to move their car. Judgment for the plaintiff for $1,700. Court is adjourned.
Here is what both of these cases have in common, and it is not the dollar amounts. It is the moment each defendant walked into court believing their version of the story was so reasonable that evidence would be optional. One thought a cleaning offer was enough without ever getting a cleaning estimate. One thought a verbal dispute of a repair bill was enough without a competing written estimate. Neither brought the paperwork. The court record for We the People with Judge Lauren Lake is publicly available through syndication disclosures and court proceeding summaries filed with production. Go find the case filings. Look at what was submitted as Exhibit A in the Ryan matter. Then come back to the comments and answer this. If Shadow had been kenneled during that 7-hour party, as Judge Lake noted dog trainers actually recommend,
there was a lack of communication between you two, to me, that caused this to happen. Now, Mr. Tran, $3,000 for a brand new mattress because you left a dog in the house all day. I still feel like a reasonable person in this circumstance would know better.
Your Honor.
And that just poop pads on the floor may not be enough. However, I think it's outside the realm of what I would think would be possible that little Miss Diva would poop on the bed. Now, I would think maybe it would be somewhere else besides the pad, but I would not have thought it would be on the bed. I personally don't want to sleep in a bed where a dog has pooped. However, the dog didn't poop on the mattress, the dog pooped on the comforter. And there was nothing there. You've presented no evidence to this court that would suggest—
Does this case exist at all? If this kind of evidence-first breakdown is what you came here for, like this video, share it, subscribe to Real Court Case Verdict, and turn on notifications. We don't editorialize. We follow the record. And the record in both of these cases had a lot to say.